All right, it is Wendy Hernandez, and I am back with another quick end of the day tip video. I'm a Phoenix family law attorney. I'm also the creator of Command the Courtroom. If you haven't checked out the Command the Courtroom videos on YouTube, go do that now. There's hundreds of videos there that will help you if you're going through a child custody case. Before I dive into what I'm going to talk about today, I want to remind you, if you're watching this now or you're watching this later, that this coming Friday is Free Training Friday. Friday the 13th, September 13th, I'm going to have a free training on evidence gathering techniques. I've been getting questions about how to decide what evidence to gather for your child custody case. So during the training, I am going to go through my process, how I select evidence, and just a general system that I use for deciding what evidence will best support my client. So if you're interested in the training, the link is in the description for this video. Sign up. If for some reason you can't sign up, send an email to wendy@commandthecourtroom.com and I'll get you signed up. A couple of people have had difficulty signing up. Okay, so let me talk about quickly what I'm going to talk about, which relates to evidence. Let me know if you're there and if you can hear me. So, not all evidence is created equally. Not all evidence is going to be admissible at your trial. So, as you're gathering your evidence, you have to ask yourself a couple of questions. And one of the questions you have to ask yourself is whether or not the evidence you're considering getting and disclosing to the other side is evidence which is actually going to help the judge make decisions about your case. Hey, NH Rebels, good to see you again. So again, you have to evaluate your evidence very carefully to make sure that it's actually relevant to the issues in dispute. So there are tons of rules in the law, and I think that's part of what makes child custody and family law cases so confusing and overwhelming to people. You have your rules of procedure, you have your local rules, you have case law, you have your judge's rules, and you have the rules of evidence once you get to trial. And the rules of evidence are going to govern whether or not your judge admits certain evidence at trial. So, when you're in the process of gathering your evidence in anticipation of trial, you need to think about trial down the road and whether or not this evidence is actually evidence that the good judge could potentially admit. Um, so, in evaluating your evidence as you're going, and so you don't spend time going around collecting a bunch of unnecessary evidence, ask yourself, is this evidence actually relevant to the issues in dispute? Is this evidence likely to make, is this evidence likely to, does this evidence speak to the issues in dispute? Does this evidence make one of the issues more likely or less likely? So hopefully that makes sense. A lot of times I have clients come to me and they want to use information and it's not really relevant to the issues in dispute. For example, in Arizona, we are a no fault state. So in Arizona, a judge really doesn't care if one party cheated on the other party when it comes to issues of child custody. That is the general rule. However, if one parent has a partner in their life or cheated with somebody who has a drug or alcohol or substance abuse or domestic violence issue, well, then that would make evidence surrounding this partner relevant to the issue of child custody. The fact that there was infidelity alone in and of itself is not relevant to the issue of child custody or legal decision making in Arizona. So hopefully that helps you distinguish a little bit about what it means to have relevant evidence and non-relevant evidence. You should be going through each piece of evidence with a fine-tooth comb and checking it to make sure it's relevant. And I have a little, actually, I was looking at some things earlier today, some old stuff I did, and I have a um, evidence screening worksheet that I found. I'm just going to share it with you super quickly. I think you can see that. It's the evidence screening worksheet. It's part of a program that I did a while ago that hopefully I'm going to redo soon. So, in this evidence screening worksheet, you go through and you can make this worksheet on your own. You can screenshot what I'm showing you here. but you list out the piece of evidence that you want to try to admit at trial. And then you answer the next prompt, which is this piece of evidence is relevant because it tends to disprove or prove the following material issue or fact in my case. So that's the first hurdle that you have to get over in terms of selecting evidence. Now, I'm not going to go on and confuse you with the other questions. Reliable, the evidence is reliable, and the evidence is right. These are other requirements according to the rules of evidence, but actually those are good subjects for videos in coming days. For right now, I want you to think about evidence and that you're considering presenting in your case, whether it's relevant, whether it tends to prove or disprove the following material issue or fact in your case. As an example, say that the other parent's care of the children when the children are with them is at issue. One piece of relevant evidence might be medical reports and medical reports showing that the children are sick a lot or that the children have gotten injured when they're in the other parent's care. That would be a relevant piece of evidence because it would tend to prove or disprove a material issue or fact in the case. So I'm hoping that makes sense. You cannot just get any old piece of evidence and throw it into trial and think that the judge is going to consider it. You first have to show the judge why it's relevant. If you get objected to on the basis of relevance and you cannot explain why it matters in your case, that evidence is probably going to be rejected. You're not going to be able to admit it. And I can tell you that probably the most common objection that I personally make when I'm in trial is a relevance objection. It's probably the easiest one. It's the one at the top of my head. And a lot of times I am able to keep evidence out just on the basis of a relevance objection alone. So we're going to delve more into what it takes to get evidence admitted at trial in coming days. But I just wanted to touch on that. I did send an email out to any of you who are on my email list about relevant evidence today. If you haven't read that email, check it out. Take a look at it. I explain more what it means for evidence to be relevant. And also, I want to remind you again about the training that is coming up this Friday, Free Training Friday, Friday the 13th. And we're going to talk about gathering evidence, my process for gathering evidence. I'm hoping that I can help you by modeling what I do, help you make decisions about what evidence you're going to collect, gather, pursue in your own child custody case. I'm hoping that if I model what I do, you're going to get a better idea about how to decide what may impact your case. And during the training, it's going to be cool. We're going to go through some fact patterns and kind of like I did in law school when I was a student. Our final exams were essentially big, long fact patterns, which are stories about people or situations. And then I would have to write, your law students have to write and analyze those fact patterns according to the law. So I have created some fact patterns that we're going to talk about, and then we're going to analyze them according to the best interest factors, one of my favorite things to talk about, and also based on those best interest factors that apply, what potential pieces of evidence could exist or that you could gather. So I hope that makes sense. I don't have much else to say. We're going to talk more evidence tomorrow, Wednesday, and the next day. And then Friday is the training. If you have not already signed up for the training, do that now. The link is in the description. Also, let me know if you have comments or questions. Like, I love getting questions from you because they help me decide what videos I'm going to do next. If I get a question a lot, then likely it's going to be a video in the future. Also, it helps me help people clear up areas where they're foggy, where they don't understand, where they need help. Please understand, I cannot give individual advice to people. I'm only licensed in Arizona. I can only give general information, educational information, like as though I were writing a book and you were reading the book. I cannot speak to individual circumstances. I appreciate everybody's email messages, but I cannot respond to each email message and give individual advice, especially for people who live outside of Arizona. If you live in Arizona, we can schedule a consultation and I can talk to you. but I cannot give individual advice. And I get tons of emails from Command the Courtroom viewers, and there's just no way I could do it, even if I were ethically allowed to do it. But my way to help you is to give the free training, give information, and I do have some trainings already on YouTube that I recently did on judges and changing judges. I don't know what a 170.6 block disqualification is. No idea what that is. I can't speak to that. I'm sure a different state other than Arizona, because I've never heard of that. But I appreciate it, KT. And look at the video on changing judges that I did a couple weeks ago. Maybe that'll help you. And I wish I were licensed in all 50 states, but unfortunately, I'm not. I don't ever want to take another law school exam or a bar exam in my life. Took me my second try to pass the one I did. That was a long time ago. Anyways, guys, I hope that these videos have been helpful. I hope you like the longer videos on YouTube. If you haven't already subscribed to the email list, go to commandthecourtroom.com, sign up for that best interest checklist, register for the upcoming training, and I think that's it. All right. Have a good night. It's Tuesday, y'all. So we are rounding the corner to the middle of the week, and I'm going to talk to you tomorrow. And put your thinking cap on. Get ready to get out there and command the courtroom, and I'll see you soon. Bye.